guys. Hey guys. Hey.
This is not your average podcast, trust me. This is IPSERIES, where you learn to protect and safeguard all your intellectual property so you can make a career of what you love. Join me, Rita Chinda, as we discuss all things intellectual property from the world of fashion, film, media, entertainment, dispute resolution, and even technology. Welcome. Welcome to IPSERIES. So please kindly introduce yourself. Tell us who you are, what you do, and where you're based.
Hi Rita, how are you doing? My name is Tope Tokan Lawal. I'm a partner at Oshuntuyi and Tokan Lawal Law, which is a small law firm in Lagos. I'm a licensed lawyer in both Texas and in Nigeria, and I have over 12 years experience representing clients in intellectual property disputes, arbitration, litigation. I also do corporate and commercial law and family law. I also represent child offenders. I have a BBA in management and a JD actually, and then I have my LLM in human rights and economic development. And I also run two charities, one for education and then one for legal advocacy for children.
Wow, that's good. Your CV is choking right now.
Thank you.
Okay, so we're going to be delving into the conversation on obtaining judgment on injunctions to protect your copyright upon filing a lawsuit throughout the court proceeding and on a perpetual basis. So for a start, what would you say is copyright? Basically, what's copyright? What does it really entail? How do you protect your copyright? If your work gets infringed, what do you do in that instance?
So in the most basic of sense, copyright is a type of intellectual property and it's the most basic in the sense that it's prevalent and it's easy. It's something where you can write a love letter and somebody steals it and publishes it and you have a case against somebody for literary work. So that's copyright. And what makes it special is also the fact that unlike the other types of IP, you don't have to register it before you get protected. There are certain requirements, but once you meet those requirements, basically, that means you expressed whether it's words or music or audiovisual work, or broadcasting or photograph. Once you expressed it in a tangible form. So if it's words, you wrote it down on paper, or you spoke it into an audio. Those sort of things. You should have copyright, ideally. In Nigeria, we currently have the Copyright Act 2022, which replaced the Copyright Act 1988. And under the Copyright Act 2022, it protects 6 broad areas of works. So we have the literary works, which I kind of mentioned with the notes or a letter, the musical works, the artistic works, so your drawings, audiovisual works, sound recordings, and broadcasts. Another thing is copyright is not perpetual. So once you get that protection, it does have a limited time. So for example, for literary, musical, artistic works, excluding photographs, it lasts for 70 years from the end of the year that the author or owner dies. And then for other types too, so audiovisual works and photographs, for example, they only last for 50 years after the year in which the work was first published. Simply put, the author owns the copyrights on their works. However they wish to use it, they can assign it, they can license it, and copyright can even be broken down to different rights. So you can license, maybe if you wrote a letter, you can license the right to speak it into an audio form to one person, and then license, somebody to draw it into an artistic form to somebody else. So it's a bundle of rights per se. Infringement would happen if somebody uses your copyright without permission or license. Since you have the full bundle of rights, so anyone who uses it without your license, authorization, or knowledge infringes on it. Ideally, for copyright, you don't have to register it. But it's advisable if you can, you should register it so that at least you have some kind of proof and evidence. But it doesn't mean that you don't have proof when it is not registered. Like as I mentioned, infringement happens when somebody uses it or produces your copyright protected material without permission. So an interesting thing about copyright is that when there's an infringement, there is a civil remedy, and then the person can also be prosecuted criminally if they infringe on your copyright. So under the Copyright Act, so if you are the owner, licensee, or I think authorized third party, where there is an action for the infringement of copyright, that will be the plaintiff, and they are entitled to reliefs, and the reliefs can be damages, which is like monetary, injunctions, which what I'll speak on later, and then accounts, which is for them to account for any profit or income that they have made from your copyright.
Okay, thank you so much for that introduction. Moving on to the next question. How would you describe? I know when you were talking about yourself, you mentioned that you do a bit of dispute resolution. So when it comes to copyrighted disputes, would you say dispute resolution is like the best mode for resolving copyright disputes?
I would say yes. And that would be because dispute resolution, yes, there's different types of mechanisms. So ideally it's litigation, and then there's alternative dispute resolution mechanism, which is negotiation, mediation, arbitration. And so I think to bring it down and to just think of it simply, when you have a copyright, you can actually negotiate with anyone, or even if it's multiple people that worked on it, the process of you having a contract with somebody involved negotiation, which is dispute resolution mechanism. Ideally, if all things being equal, like people say, if you have a copyright or you have co-owners and you can competently negotiate with these people or hire attorneys, then ideally it is best that you negotiate because it's freer. You don't have a third party that is involved. It's just the two parties. It's limitless that both of you can agree, or both of you or more people involved can agree on any number of things. You can agree on how many rights a person has, or how these rights can be exercised, or how long these rights can be exercised. So that negotiation gives you a full-blown freedom, per se, to agree on different ways to share and own the copyrights. But now negotiation also hinges on lack of disputes and disagreements. So obviously where there's a disagreement, yes, you may be able to negotiate and settle out of court per se. But if you do have a contract, you could mediate or you could arbitrate. You don't need a contract to mediate, but you should agree on it, or it could be court attached. But that's also another mechanism where you have a third party, that's a neutral third party who is known as the mediator, and their goal is basically to assist the parties to settle and agree on mutually beneficial outcome. So the next is also arbitration. So arbitration, mandatorily, it must be by agreement of the parties. So whether you have an arbitration contract or clause in an agreement, there is a limit to what you can do with arbitration and mediation. And I'll get to that when I speak on litigation and the Federal High Court, because as it stands now, in Nigeria, only the Federal High Court has the exclusive jurisdiction to determine copyrights. And that's like, okay, who owns it? How much do you own specifically? But where there's no issue with actual ownership or the amount of ownership or the basis of the ownership, then the parties can agree, they can mediate. So when it comes to profits or sharing ratio or other ways of using the copyrights, they can agree and either mediate or arbitrate. The good thing about mediation now is that with the new Arbitration and Mediation Act, a mediation agreement and an arbitration award, but the arbitration award has always been like a judgment, but now agreements following the mediation can also be taken to courts and applied to be a consent judgment.
Yay, fantastic. So are there like specific disputes in terms of resolving dispute if you're either going to litigate or if you're going to opt for ADR proceedings like negotiation, arbitration, or litigation? But then just also highlight the litigation aspect of resolving copyrighted dispute and the role that the Federal High Court plays in all of this.
So under the Constitution, the Federal High Court has the exclusive jurisdiction to decide copyright cases. What it means is that when it comes to disagreements, parties are unable to decide who owns the copyright, or there is an infringer and there is conflicts, basically, then it has to be the Federal High Court. Now, the ADR mechanisms also involve some level of agreements, cooperation between the parties. So obviously, if there is no agreement, there's a full-blown dispute, then the Federal High Court. But if the parties are able to agree on the ownership, and it's just ancillary issues like monetary profits and ancillary matters, then they should be able to arbitrate or mediate or even just negotiate and have an agreement.
All right. So what would you say are the available remedies in terms of injunction and other legal and procedural requirements that copyright owners in Nigeria need to take note of?
So I mentioned earlier that there are remedies that a plaintiff can have where there's an infringement on their copyright. And that's basically somebody is using your copyright without your permission, or they are still benefiting from your copyrights without your permission or license or authorization. Now, the Copyright Act entitles the plaintiff to sue for damages, which is money, and then an injunction or account for profits, basically requiring the defendant to account for how much they have earned by infringing on your copyright. And there's also the criminal element. Now, injunction, as stated here, so there are 3 different types of injunction, and they come into play at different parts of the lawsuit. So now we're moving to litigation specifically, and this is if you have a litigation that involves copyright, then it has to be at the Federal High Court because it's the courts in Nigeria with exclusive jurisdiction. So these 3 injunctions, they're called interim injunction, interlocutory injunction, and then there's perpetual injunction. So when you have a case, when you believe that somebody has infringed on your copyrights and you decide to go to courts, you get a lawyer, or I don't think you can represent yourself, but ideally you should get a lawyer and you prepare your originating processes. So these are what we call the writ of summons, your witness statements, and your documents. Now, attached to this originating process, the first will be the interim injunction. And this is advisable where you have an urgency that relates to the infringement, So for example, somebody stole your song and then you found out that they've included in their album and the album released within 30 days or maybe 20 days from now. So you tell your lawyer, you file the lawsuit, and you can actually utilize the interim injunction. And this is basically to restrain the infringer from ideally including it in their album or even releasing the album with your copyrighted material. Now, for an interim injunction, you have 4 sets of documents. So first you will have your motion or notice, and this will state your prayers. The advice is that the motion on notice has to be specific. So as a lawyer or as the client even speaking with your lawyer, your prayers, that's what they call them, what you're asking the court to do has to be specific. So you can't just say, the court should say they've infringed on your copyright. Ideally, with the example I've given, you will say, restraining Mr. So-and-so from releasing my song as part of their album or as a solo or using it in any way or publishing it in any manner. So it's specific, but then there's also the broad side. You can also add other things. So one thing I've done in the past is having a prayer to publish the court order. Because another thing with litigation is that before you even get to litigation, there's typically will have been a pre-action notice or a cease and desist. So the assumption is you as a plaintiff, you probably wrote to this person once or twice saying, look, this is my song, don't release it or pay for it if you want to release it. So that's the assumption that you have made attempts. So them not even listening to you or trying to settle the matter out of court, or maybe there's some hard-headedness going on, you may then try to have some type of publicity involved, ideally because it's a shame and name type of situation where you say, okay, pray for an order where you can publish the order, like the court order, restraining them in a newspaper or on social media, because by default, you may not be able to publish it. So it's good to also ask the courts for an order where you can publish the order in newspapers or social media or any other place. Another prayer that I've also found very useful is that with songs or other types of copyrights, the person may have actually taken steps to register them in international bodies or international copyrights entities or online platforms. So you may have a prayer ordering the defendants to write to these parties and asking them to take down his ownership or the interest in the copyrights, amongst other things. So these are some of the prayers that you can put in the interim injunction. Now, in support of your motion ex parte, okay, so an interim injunction is done without notice. So it's a motion ex parte, that means without notice to the other party. Now, in support of this, you would have an affidavit. And in my opinion, I think your affidavit is actually one of the most important things that you will file in support of your motion or notice, because it has to show the courts that what you're asking for, you're entitled to it. And so even though the written address in support, which is what the legal arguments will have, and it has to meet certain elements, your affidavit itself, even with the facts, without even being argumentative with the facts, as it would also show the courts that even before they read the written address that, look, these facts already meet the elements. So it's a few elements for the interim injunction. So showing that you have a legal right, that means you are entitled to the copyright. So in your affidavit, you state how you created the song, the steps that you took to create the song and how it is yours and not just that other person's. And then you state how the defendant has infringed on your rights. So they're using it, they put it on the album, like I said, or they are ready to publish it in a few days, in a few months. And also the fact that because it's yours, and if once they publish it, it's out there, it might be too late to retract it. Or basically, once it's out there, to be honest, the way social media is, once it's out there, it's really out there. So even if there's an order subsequently, it might be too late because it's already out there. There's also the issue of balancing the convenience. So this is basically the court looking at fairness and saying, okay, how much will this help the plaintiff that is asking for us to issue an order to prevent the defendant from publishing the song versus how much will it hurt the defendant? Because yes, you say that it's your song, but there's a chance that it could be the defendant's song. So you need to properly show the court that you have the legal rights and you are entitled to it, in the sense that the court would want to take the risk of preventing the defendant from publishing the song, as opposed to publishing the song when it turns out that it's not actually yours. So with interim injunction, it's based on urgency. So like I said, the album is about to release. You need to show the court, today is this date. There's evidence that it's going to be released in 2 weeks or a week. We need this injunction ASAP. And also that you haven't delayed. So it's not a thing where you knew about this for 7 months and you never took any steps. But then the delay can also be based on you trying to. So if there's a situation where you had been trying to settle out of court, I've had situations where we listed the attempts to settle out of court, which spanned over a year and a half. So that would also be saying there's no delay. The delay in us filing the suit is because we consistently tried to avoid coming to court. And I've had situations where the courts agreed with us that was not a delay because, settlements are always advisable, even by the courts. And then you must also have, like I said, the interim injunction will come with the substantive lawsuit. So there has to be the bundle of originating processes already filed. Other points that you also show is that the loss is a great loss because this is a song that you work so hard on. If it's out there, they'll make all the money. You won't make money. Another point is that money is not enough. So with the song, like I said, if they release it, it's going to be in their name. This sort of thing, it's yours. So the defendant paying you is arguably inadequate. And then you always have to have that undertaking that if this turns out to be false, then I will pay the defendants. And then there's also the issue of special circumstances. It's on a case-by-case basis. You can state many reasons for special circumstances. I can't think of any right now off the top of my head. So that's the motion on notice, the affidavits. And then obviously the affidavit is not just you stating facts. You have to attach documents, pictures, videos, writings, audio recordings, as many things that you can attach in support, because the court is basically reading a piece of paper and the court has to believe what's on paper based on what you're telling the court, because this is ex parte. There's no defendant coming to defend themselves. So you need to put as much information forward to convince the court that, look, I'm entitled to this, and you granting it is not at risk of it being, my information is not false, basically. So you have to also try and convince the court based on your evidence. And then finally, you have the written address, which is your lawyer applying your legal arguments, case laws, legal authorities to support the facts that you have already presented in your interim injunction. So yes, now the interim injunction is done at the beginning of the suit. Once you file your bundle of documents, you apply to the courts, you let them know that there's an urgency. And typically in Federal High Court, they're quite good with urgent interim injunctions. I've had cases where within a month or within a week or two, you get a hearing date, you hear it, and you have a court order that is ready to go out in a short period of time. In addition to your interim injunction, you also have to file an interlocutory injunction. One thing I will say is that the interim injunction is not perpetual. It's a very short, limited period. Typically, under the law, it's 7 to 14 days. But in my experience, what I've seen is that the interim injunction is actually granted pending the hearing and determination of the interlocutory injunction. And sometimes, before you even hear the interlocutory injunction, it may take a week or a month, depending on how soon you can get a subsequent date. So the interlocutory injunction is very similar to the interim injunction. It's just that, unlike the motion ex parte, it's on notice. So this has to be, typically when you get the order from the interim injunction, you attach it to the motion on notice, and then the court processes are now served on the defendant, and they finally have notice of everything and the lawsuit. So the interlocutory injunction is intended to last throughout the lawsuit. So once you start with the interim injunction, the court has restrained the defendant from publishing the song, and you proceed to have the trial or proceedings, then you would also need an interlocutory injunction to maintain the status quo per se throughout the proceedings and prevent the defendant from going ahead to publish it after the interim injunction lapses.
Seriously, if you want to transform your IP knowledge from to come and hang out with us on the IP series podcast. We're here to inspire, to educate, and entertain you on your journey to understanding how intangible asset works. So subscribe today and let's make IP the most interesting conversation. Else, we're gonna have a problem, guys. Please subscribe, okay? Hit that subscribe button and join the party.
The requirements of an interlocutory injunction. So basically, same thing. You have a motion of notice and your affidavit, and by your affidavit evidence, you also try to prove that you have a serious question, you have a copyright. You list your entitlement to the copyright and how you qualify to have a copyright under the law, and then you also talk about the balancing the conveniences. What's the benefits to grant the application in your favor or to deny the defendant? So there's the court balancing the interest of both parties and see who's going to lose more, who's going to win more, type of thing on a scale. And then another thing with injunction is that it's not money. It's restraining or forcing a party to do something or restraining them from doing something. So you also have to show that money is not sufficient. One thing I've noticed with injunction is that where the court does agree that you have a strong case or a serious question, the court can be more inclined to require the defendant to account for profits. That's in a situation where maybe the defendant also has some interest, maybe in the copyrights, or maybe there is an issue of it's a collaboration, it's not just your product. So ideally, if you can show that it's your song, they stole it outrightly and they have no interest in using it or relying on it, then you should be able to try and convince the court that, look, an injunction is the only way. Money is not enough. But oftentimes the defendants come and they say, look, we own the song, we worked on it together. Maybe the plaintiff is just trying to be greedy. Let's do an account for profits. We would undertake that, look, any money that is being made, we would share it with the defendants over time. And the court will be more inclined to to agree with that or not. And then the next is to show that you're not guilty of delay or any reprehensible conduct. And then finally, it's having an undertaking to damages. And because of the nature of an injunction and the likelihood that you may not have been entitled the way you were, but then here is the defendant not being able to release an album that they worked so hard on, also not undermining your copyright, obviously, but let's just say the defendant also worked hard on their album, then the plaintiff will also have to undertake that in the event that, my claim is wrong, I wasn't entitled, then I would, pay damages to the defendant. And then the final type of injunction, which is intended to last perpetually, that's the one that is a prayer that is included in your substantive lawsuit. So that would be your statement of claim. So that would be a prayer for perpetual injunction restraining the defendants from including it, from performing it, from licensing it, from assigning it to themselves or their agents or whosoever in the world.
Fantastic. I mean, it sounds simple, but I know that it's not simple, but it takes a lot. Yeah, you have to need to be creative and strategic in all your proceedings and your draft. But in an instance where you have a case where someone had, I think you alluded to your conversation, first one waits for, say, at least 10 years before coming to apply to court. What are the implications for not commencing an infringement suit on time? Is there a timeline for that? Or do you just, wake up one day and say, oh, I think this person infringed on my song? I think a typical example would be Mariah Carey. I think every year she's being sued by one person that claims All I Want for Christmas is similar to their own song. So what is the ideal timeline for commencing a litigation lawsuit? And what do you really need to do? What are the strategies you need to put in place to ensure that you actually win if you really do have a case?
I think it depends on the situations and the facts at hand. In the basic sense, you have your copyright for your lifetime. So that's the owner. You have a copyright for your lifetime. If it's government agency or company, it's for a specific time after it was created. So ideally, in your lifetime, you can consistently and continually sue. There's no statute of limitation on how long you can sue an infringer for infringing on your copyrights. However, if it's, let's say, for example, you had a contract and you licensed it, I would believe that the contract laws, that means breach of contract laws, would apply. So if, there's a breach of contract and you wait for 7 years, let's say, in Lagos now it's 6 years. So if you wait for 7 years, arguably, the defendants could argue that, look, I breached this thing for too long and you did not sue me within the limited time. I mean, I would say in that situation, I will still argue that, look, my copyright is perpetual, and I'll be sorry, in my lifetime and afterwards, you should be able to protect it, even if you infringed on it 10 years ago. But I don't think we have a specific case on that, whether it's the contracts, the breach happened more than 6 years ago and it had to do with it. Actually, I think we might, but I would like to know how these cases turn out. Oh yeah, so another point I was going to make on that is that if the infringement happened 10 years ago, I don't think you may be able to get an interim injunction or even an interlocutory injunction because of that delay factor in both of them. So that delay factor, it will be difficult to say that there was no delay. But then again, you never know. It could have been where you genuinely didn't have any notice of the infringement. No, maybe it wasn't on social media. The person was just putting it in their gallery and showing people where you could not reasonably have discovered the infringement. So yes, that's actually an argument. They put in their gallery in some place in Lokoja and you didn't know, and people were taking pictures and they were making money from it without your permission. And you didn't know that your artwork was not even with you anymore, something like that. I thought it was with somebody else. So yes, arguably, honestly, it depends on the case actually. You can actually present facts to show that, look, yes, it's been 10 years or it was 10 years ago, but I could not reasonably have discovered this and I didn't delay. And as soon as I found out, I applied for this interim injunction. You may actually successfully convince the court.
Interesting. I mean, with your argument so far and your information you shared, I'm tempted to say litigation is like the best thing for me for having.
No.
Oh, God.
No, litigation can be very slow. It can be very slow, and you may get, I don't want to say anything about specific judges, but you may get unlucky with the judge, and it's, a judge getting elevated in the middle of your case. So you have to start all over again. So yes, you may get lucky, but you may get unlucky. I would say if you absolutely cannot settle out of court or agree, then litigation is the way. And as a defendant, I would say if you think you're in the wrong, it doesn't look good on you as a defendant where there is a judgment against you for infringement. I would say that. So always try to settle out of court if you can.
Always try.
Because litigation is public. Yeah, proceedings are public. Every information, once it's in the court documents, is public.
Especially now that we're dealing with so there's the court, the legal court, and then you now have the public court where everyone has a view as to how the matter has been done.
The opinions, yes.
The judge was too sentimental. Too many back and forth. We're in the era of social media call-outs and dragging and people doing things for that.
Yeah.
It's been an interesting conversation. I think I've never really had anyone on my podcast give like an in-depth overview of what copyright litigation is and dispute resolution aspect in them. So in summary and in conclusion, what is your final words when it comes to creatives, not just artists now, but creatives generally in terms of how they can comment copyright suits, lawsuits in Nigeria? And then for lawyers who may be listening to you within Nigeria or outside Nigeria, what those things that they really need to pay attention to when it comes to resolving copyright disputes and also obtaining injunction to protect the subject matter?
All right. So first, I would say we are all creative, and even this nation is being driven by creatives. There's somebody coming up with new ideas, great ideas, and you can't work so hard to create your new idea and then have somebody else steal it and benefit from it. It's terrible. It's a terrible thing. And so the idea is protect your copyright when you can. I know there are financial constraints, but if you have it and you've written it down, take steps to protect it. And I can't think of non-legal ways besides trying to register your copyright if you can afford to. Obviously, I know photographers nowadays, they all put their logos and their names in strategic areas of the pictures. So if you're an artist, put your name. If you post something, put your name. Make it easy so that people can determine that you are the owner. You don't want a situation where somebody else reposts this and they go viral, they make all the money, and then you, with all the effort and the time, you've lost the benefits. If you're a music producer, try and get contracts before you even start playing the songs for these people. If you're sending musical compositions to artists, try and get an NDA, try and get some type of written agreement. It could even be a WhatsApp chat saying, oh, this is my song, I'm sending it to you to record and consider. You cannot use it without my permission or ownership. If you want to use it, you must agree on payment. Something very simple. And I know everyone has a friend that is a lawyer. They know somebody that knows a lawyer. Ask them. You never know. Like somebody said, start with them. Even if it's their first or second year, start with them and see. By the time they advise you for a year or two, they will also be experienced lawyers and be talking on podcasts like me. So yes, take steps to protect your copyright. So don't just be too quick to publish it and put it out there. Somebody might take it and it might be too late. The world appreciates good work, so try and take steps to protect it. For you lawyers that want to represent clients, always advise them to have a contract, even if it's something very simple. Advise them that, look, you might be too excited. Oh, this big person came and they want to listen to your sound or your beats. Tell them, just, slip this document in and let them know that, okay, look, this is, you have to sign this, or you have to send them a copy of a contract, or letting them know that, look, by reading this or by listening to this song, you're not entitled to have it for yourself without paying me or getting a proper license. And just try to protect your client's interest at all times. And if you do have to go to court, ensure that you do try some pre-action attempts at settlements, because this will also go into your filings showing the court that, look, these are the steps that I took to settle the matter out of court. And then when you do get to court, your documents, your evidence is so important. And like I said, I think your affidavit evidence has to be very strong. You can have 20 pages of legal arguments and you lose the case because your affidavit is not convincing the court that these facts are sufficient to convince me that, look, you own it and you're entitled to it. Like I say to people, you can have a 10-page affidavit and then a 1-page legal argument and you win the case because the facts convince the court, the documents in support and the evidence convince the court. Also, so going back to the creatives, when you share your work or you talk to people about your work, document it. If instead of having a call, go through a chat, go through an email, so that at least when there is a dispute, and my favorite cases where I handle is where I ask the client, how do you prove that it's yours? And they send me chats, audio, video, email, and there's like I had one where he literally had a record for every single day up until when the person came to the house, spoke to the person, had meetings, and was so well documented that the interim injunction was it was very easy. Even the court was impressed with the amount of information that was provided. So It will help your case. Yes. So don't be too excited. If you can, document. And for your lawyer, make sure you put the facts chronologically, explain to the judge, because again, you may not get a chance to actually orally argue in court. So a lot of times judges will say move in terms. You may beg and say, oh, can I enumerate? And be like, no, I have a full docket. So let your document also speak for itself. Don't think that you get to court and start arguing and adding one case. Research, ask for precedents from 10 people. Even till now, when I do cases and I still talk to people about how would you make this argument, how would you do it? So keep learning, keep building your arguments. Your last court filing shouldn't be exactly the same as the new one. You should have shown some level of growth and maturity and additional knowledge. So yes, that would be my advice to the creatives and also the young lawyers.
Very important takes right there. Thank you so much, Tope. So
Thank you.
I know how I can reach you, but then to my listeners, if they want to reach out to me, without coming to me, they'll push me aside. How can someone reach out to you, Tope, if they need to ask you more questions, they need to consult, or they need to retain you to be their litigation lawyer or anything?
All right. So, like I said, I'm a partner at A Tope Tokan Lawal Law. We are also known as OTL Law, which are initials. So our website, you can visit our website, which is otllaw.com. You can reach me by email, which is a.tokanlawal@otllaw.com. And you can also reach me on LinkedIn, which is just my full name, Tope Tokan Lawal. If you're in Lagos, our office is in Ilupeju, and you can check for our address and make an appointment to come in. Yes, and if you see me at a conference or on the road, you can always say hi.
Very important. Your face has to be out there. So when I meet you, I say hi. I heard you on Anne's podcast. It's very nice to meet you. Yes, so thank you so much.
Thank you for having me. Thank you. I really enjoyed speaking.
I'm happy to hear that. Thank you, Tope. I really do appreciate this.
You're welcome.
Thank you for listening to IP Series Podcast. If you enjoyed this episode, please subscribe, rate, and review us on your favorite podcast platform. Don't forget to share it with your friends, family, and colleagues. You can also follow us on Instagram at IPSERIES with Esmeraldo ESQ, or Twitter at IPSeries1, or send us an email to ipseriesinfo@gmail.com. Until next time, stay tuned and stay informed.